We are delighted to have a Young ICSID event. You have some old ICSIDites here as well. I hope we're not interlopers. But we are especially pleased to be celebrating this beautiful volume. The International Law Commission began its project on state responsibility in 1955, and it was steered by a number of rapporteurs, all people with famous international law names that you will have heard of from your studies. But the fifth and final rapporteur was Judge James Crawford, who took on the mandate in 1997, and he steered this through to adoption by the United Nations General Assembly in December of 2001. So by 2021, we had got to the 20th anniversary, and we thought this would be an apt topic for a special issue of the ICSID Review, and hence, we ended up with this beautiful volume. And it is really a tremendous contribution, I think, to the scholarship.
Recording stopped.
And an impressive collection of articles.
Recording in progress.
And other types of products. I think in particular, something that's very interesting is we have a case survey that adds on to a case survey that Judge Crawford originally did in 2010, showing the number of ICSID and ISDS cases that dealt with the state responsibility articles. And that has now been updated and expanded, and just in and of itself is a tremendous resource. There's also a very good annotated bibliography, and as you will see, some wonderful articles by some tremendous scholars. And today we are very lucky to have the opportunity to discuss some of the pieces that have made their way into this volume. Our panel members are all contributors to this volume, and again, I think you know them all very well, but very quickly we have joining us remotely Freya Baetens, who is a professor of public international law at Oxford University. We have beside me here David Atanasio, who is an associate at Decker in Washington. We have Christina Bahari, who is a partner at Foley Hoag, and she is also joining us remotely. And then here, Patrick Pearsall, who is a partner here at Allen Overy. Our plan for tonight is to have each of our contributors talk first of all to the piece that they wrote, and then we'd like to have a wider ranging discussion. And I strongly encourage you in the audience to make questions or give your comments or share your views. We would be more than delighted for that. So what we'd like to do is start with Freya. Freya, you were one of our special guest editors for this special issue.
Recording in progress.
And your introduction basically set the scene for the whole ICSID Review issue. So I wonder if you could talk a little bit about your article. And it is titled More Than a Plank in a Shipwreck, which is, as anyone who's read this jurisprudence and read the work from Judge Crawford, we know that that metaphor had particular meaning and is one that's sort of carried on throughout this case law. So Freya, if you would perhaps start us off and tell us a little bit about your contribution and your view about how these state responsibility articles interact with investor-state dispute settlement. Over to you.
Thank you very much, Meg, and thank you very much to all the organizers of this event. I'm really delighted that I could join you, albeit virtually. It's better than nothing. I would have preferred to be there, but this is good too. In 2010, James Crawford, as you already mentioned,
Recording stopped.
Wrote an article on investment arbitration and the ILC Articles on state responsibility in the previous special issue of the ICSID Review. And in that article, he wrote the sentence, investment tribunals displayed a certain tendency to seize on the articles as a tabula in naufragio or a plank in a shipwreck. And now that another decade has passed, I thought, we thought it was good to reassess this notion, see whether this is still true, or whether it has moved beyond a blank. And of course, the world has changed since 2010. But we thought many of the original articles' observations still hold true today. Investment tribunals have extensively relied on the ILC articles. They are actually the most prolific users of all adjudication mechanisms of the ILC articles, as you can see also in the list of ICSID cases in the appendix of this special issue. And it also remains true that some investor-state tribunals read more authority and certainty into the articles than actually warranted, at least by their formal status, without providing any kind of reasoning or methodology. They apply the articles as if they were binding law rather than a collection of a mix of codification of customary law as well as developing the law where no custom or no binding rule exists. Probably for the pragmatic reason that no better alternative is available. With regard to your broader question, how do these two relate, investor-state arbitration or investment law and the Articles on State Responsibility? Actually, the Articles on State Responsibility did not focus primarily or even especially on investment claims. On the contrary, I think many of the ILC members had believed or had good reasons to believe that in the framing of ARSIWA to distinguish this special field from general relations of states inter se arising from breaches of international law. Yet, I think, as said before, ARSIWA had an outsized influence that was probably unforeseen by the drafters. Now, if you go back far enough in time, if you look at Garcia Amador's work, for example, the first 6 reports in the 1950s and until 1961, when he was the first rapporteur, he actually, or the title back then was, "The Responsibility of the State for Injuries Caused in its Territory to the Person or Properties of Aliens." Now, that's basically a very long way of describing investor-state dispute settlement. To some extent, we've come full circle. But then, as Roberto Ago took over as special rapporteur, he started distinguishing primary and secondary rules, and then making progress in the secondary rules area and excluding substantive law. And that's how the articles got their current focus, which of course was completed by James Crawford. In the introduction of Professor McLaughlin, he refers to the articles as having their most direct application to investment claims on the topic addressed by Part 1, especially attribution, breach, circumstances precluding wrongfulness, and remedies. And that is also displayed in the sheer number of cases that rely on specifically these articles, is shown by the case survey prepared by Esme Schurler and Kabir Dubout in the special issue. I don't think this is surprising because the ILC's work was meant to stay in the form of these articles, which would not have been negotiated by states through a state conference. So there is no treaty on state responsibility to refer to, so it's obvious that if our tribunals are looking to, as an example, they will look directly at the articles. And the idea was that the articles would develop through state practice as reflecting customary law, therefore also the articles that were originally meant to develop or to show a development of international law actually gradually crystallizing into custom. And to some extent, investor-state arbitration has contributed to that. For the simple reason also that BITs do not really have many secondary rules. If you look at compensation, which we will address later, BITs only refer to legal expropriations. BITs do not prescribe a standard of compensation, or generally do not describe a standard of compensation that is due in case of a wrongful act. So it's almost necessary for parties to refer to what has been called an elaborate distillation of secondary principles that have generally been seen as reflecting custom. Even if they were not meant to apply to the context of investor-state disputes, there's no indication why international responsibility of states should be different if the responsibility is with respect to an obligation vis-à-vis another state or vis-à-vis a natural or legal person. This is not unique to investor-state arbitration. For example, you see the same in cases before regional human rights tribunals, which also deal with the responsibility of states vis-à-vis private parties, and where tribunals have referred to the ILC articles as well. Now, that doesn't mean that the ILC articles will cover each and every issue of state responsibility. There are some gaps that have been also laid bare in some cases, investor-state arbitration cases. One, for example, is that a conduct that is complained about by investors can be the conduct of a state-owned enterprise. And in that in that case, the ILC articles will offer rather little guidance. They barely refer to state-owned enterprises, and to some extent, as has been more recently stated by ILC members who were involved in these negotiations, state-owned enterprises were not really seen as actors where, that could do a great deal of damage. And that, of course, I think in the last 20 years has been shown to be not quite the case. The same applies to complicity between states and non-state actors. Again, that is something that some arbitration tribunals have dealt with in a rather creative way, because the ILC articles do not give all that much guidance. One element that has been very useful, the work of the ILC has been very useful, is the area of necessity, particularly with regard to the cases in the aftermath of the Argentinian financial crisis. And some people have said that they might play a role when a lot of cases will be brought under or against certain COVID measures. Now, so far, this avalanche of cases that some predicted or some feared has not materialized. These cases have been mainly brought before domestic courts, but that could be another area where one could arguably see a relationship where investment tribunals could find inspiration in the ILC articles. One issue that also to some extent has created a lot of controversy, increasingly so, is the standard of full reparation. That is not something that was invented by the ILC, but rather by the Permanent Court of International Justice in the Cosa factory case, and where the amount of damages have created quite a lot of criticism, saying that that kind of compensation is crippling. But there is also a discrepancy between what some tribunals have decided with regard to interest, for example, and what the ILC articles actually say. I think I have 1 minute to round up what I was planning to say. I think a last area where it would be really interesting to see what the case law will do, because again, what the ILC has prepared is not all that useful. There's the area of countermeasures or counterclaims. There, the ILC articles have not been relied upon very frequently because they're very state specific. It's not always clear how to determine who the primary right holder is. But these issues are increasing, or the desire to invoke countermeasures on the part of the state against behavior or conduct of the investor is something that is being increasingly discussed, but at the moment the tribunals do not really have jurisdiction to look at any kind of adjudication for alleged wrongs on the part of the investor, for the simple reason that these treaties only impose obligations, or the ones in existence only impose obligations on the state, a host state, and obligations for investors can be found in more in domestic law, and therefore, of course, it's not part of the applicable law of the tribunal. Some treaties have tried to address this. The domestic model, the Dutch model BIT, for example, has tried to formulate some obligations for investors, and it will be interesting to see if those treaties are actually, are concluded and enter into force. If cases are brought under these treaties, that might provide a new area where tribunals might find inspiration in the ILC articles. And to conclude, I think the relationship between the ILC articles and international investment law has been a mutually beneficial one. On the one hand, ILC articles have provided guidance where BITs offered little or none. But on the other hand, also thanks to the case law in international investment law, I think it has fulfilled a pioneering role in letting the articles come to life, letting them be applied in practice, providing some discussion on state practice and opinion juris, where we can now say that quite more substantial parts of the articles than 20 years ago have crystallized into custom. So in a way, the investment tribunals are a bit of a laboratory for the usability of ILC articles in practice. And I would say that's been a successful experiment as far as the ILC articles are concerned. So maybe I would say it's now less of a shipwreck and it starts more looking like a raft or even a seaworthy ship today compared to a decade ago. Thank you.
Thank you, Freya. Patrick, we wanted to move to your piece, which dealt with causation And we all know causation is such a fundamental thing, and yet we have seen tribunals that perhaps almost just glancingly assume causation, and then others that get into a much more involved and, as you've called it, sometimes vexing discussion of it. And I'm wondering what the ARSIWA can give to this causation discussion.
Yeah, well, first let me say I definitely drew the short straw in following Freya. That was a masterful rendition and exegesis of the connection with ARSIWA and ISDS. So I learned a lot. Thanks, Freya. And first, let me thank the ICSID review staff and ICSID generally for putting together this truly remarkable collection of essays, and I'm not talking about mine, I'm talking about the others in there, because it really is a significant contribution. I think we're really at, and generations sometimes say this, but we're at an inflection point on kind of the scope of state responsibility, I think, and certainly taking stock after 20 years and thinking forward to the next 20 years is a worthy endeavor. So, I mean, it really is just an incredible contribution. So thank you all for that. So as Meg said, I wrote about causation. It's a difficult topic, I find. It's not a difficult topic in concept, right? Because we all understand that causation is part of any inquiry with regard to whether a state is responsible or not for a wrongful act. But it is quite difficult, or at least tribunals in the investment treaty context have found it quite difficult with regard to application. So just to kind of take a step back, in order to hold a state responsible for a harm that it commits, right, one must first satisfy oneself that the state caused that harm. That's basic law, and that shouldn't be very controversial. The difficulty, though, is what that means, the inquiry itself, and how you figure it out, even at the most basic level of how would a tribunal undergo that inquiry. So, for example, if a state wrongly acts against an investment that would otherwise be valueless, regardless of that state's action, is that state responsible? Tribunals have split on that question. What if the state acts wrongfully against an investor, but there are other causes, intervening causes, that contribute to that harm, or would potentially, it's impossible to disaggregate the cause there. Does the state bear responsibility there, right? They've committed a wrongful act, and we know that a state that commits a wrongful act is responsible for that act. But if there's an intervening cause, climate change, a pandemic, does this go to damage, or does this go to responsibility, or does this go to both? And there is not a lot of theory out there on this. There's not a lot written about it, and tribunals are all over the place on the kind of analytical framework that they bring to bear on those questions. So, one of the things that we tried to do in the article is kind of just survey what tribunals have been up to with that inquiry and where it shakes out. So let me go back to the ILC articles and ground us in where the causation inquiry is located in the ILC articles, right? So the ILC articles are incredible for their brevity, and pretty incredible, especially on brevity for causation. So we go to what has become my favorite article, reparations, Article 31, and we see in Article 31.1, the responsible state is under an obligation to make full reparation for the injury caused by the Internationally Wrongful Act. So I'm sure all of you playing at home saw where the causation inquiry is required there. In case you missed it, it's two words: caused by the Internationally Wrongful Act. And that has opened up tribunals' inquiry into causation as almost a requirement, right? So there's the conceptual requirement, and then there's the locus of law. And as we heard from Freya, tribunals by application, whether directed to it or not, have started to look at the ILC articles as black letter law, mandatory law in some instances in their inquiry. Interestingly, for those of you, as a side note, for those of you who were at ICA in Edinburgh, Bruno Sima, one of the kind of architects of ARSIWA, said that they never intended Article 31 to really be used in ISDS, because ISDS was nascent, or people weren't really thinking about it as much. I found that as kind of very interesting, because obviously Article 31 is quoted all the time. Obviously, Horzo is quoted, but also Article 31. So it's interesting that they never intended, the drafters themselves never necessarily intended for Article 31 to be used as kind of a mooring post for concepts like causation. So the treaties themselves are silent as to causation almost in every instance, with a few exceptions, which I'll get to. So tribunals look to the draft articles. This is changing. So as part of the kind of, I don't know what generation we're in now, and we're at a Young ICSID event, so let's say the fifth generation of BITs, I don't know, but we're in a new generation, and I think you can locate that generation at the start of the UNCITRAL reform process. So let's assume that the new generation is 2015. There is certainly an effort in new generation BITs or new generation international investment agreements to include causation as a requirement, right? And you can date this back to the grandparent of all investment agreements, the NAFTA, the now no longer in force NAFTA, which provides that claimants may recover for loss incurred, quote, by reason of or arising out of a breach of the state. So that's a gloss on the ILC articles, but it expands on it, and it has allowed NAFTA tribunals to go a little deeper into what causation might mean. And if you look at NAFTA jurisprudence, to the extent we can call that a jurisprudence, there's much more of a rich history of looking into causation than there is in some of the first, second, and third generation ISDS cases that are just in bilateral investment treaties. And that was taken up by the CPTPP, which was meant to be the successor to the NAFTA before the USMCA got involved. And the CPTPP uses basically the identical language as the NAFTA. So that represents almost 50% of the world's GDP. So to the extent there are disputes under that agreement at some point, if things move in a different direction than the way that they're headed currently, then you'll see causation language at the forefront of tribunals grappling with questions under that agreement. So I guess the headline there is tribunals don't have a consistent approach to what the causation inquiry is. And let me throw out three unsettled questions, and then I'll move to just one or two examples that are interesting, including one by where Bruno Simo was the president of the tribunal, Bilcon. I hope it doesn't give Meg, well, she was out of government
No
by that point, so
flashbacks.
no flashbacks. So here are the three unsettled questions, and there are hundreds, really. So those of you who are looking to write in this space, I encourage you to do so, because it is really an under-theorized area. So one question is causation an independent element that connects responsibility to injury? So is it an element that connects responsibility, okay, the state did something wrong, to the injury, okay, the state caused that injury, caused by, right? Is it that, or is it an element of responsibility itself? Because how can a state be responsible unless it caused something, right? And I'm not the first to pose this question. In fact, it was kind of a central question in Pe Casado v. Chile, and Brigitte Stern said that this was a distinct step, in her view, that you need to look at the two, because in her view, traditional conceptions of responsibility can tend to collapse the inquiries into one, holding that the obligation to make reparation is not the consequence of the international responsibility, right? That's that step caused by, but is international responsibility the obligation to make reparation itself? So international responsibility is that obligation, right? So you don't need, so if you are responsible, you must repair, right? But so the causation inquiry is completely collapsed into the question of responsibility. Interesting question. I will read the article to find out a little bit of what I think, but I'm a little bit Sphinx-like on it for good reason. Okay, 2, is causation sufficient to establish the need for reparation? So is causation sufficient, right, itself? Like if you say a state caused something, then does that necessarily mean reparation? Well, factual causation, or but-for causation, is a necessary element that involves for a claim of injury, but it's not always sufficient to establish that the injury is recognized under law. So here, think about the Bywater Gulf cases, right? So there is a case versus Tanzania. There is a case where the tribunal found that what Tanzania was wrong, what they did was wrongful, okay? But the underlying investment was already moribund. It wasn't, it was basically bankrupt, et cetera. Its value was zero, right? So what do you do in that situation? The tribunal split. Gary born in dissent and Toby as president for the majority. And they split on whether, from an academic perspective, they're collapsed into one or not, and whether one is necessary and sufficient for the other. And then the third question is this kind of very tricky, I find, question about cause and fact analysis, right? So here's the question of overdetermination and where you look at whether two causes for something exist, and then how you parse that out. The Articles of State Responsibility don't speak to those questions. They don't speak to contributory negligence or concepts of unclean hands and things like that. It really is, but we're going to see a lot more of that, and I'll get to that. I'll skip a little bit along. I'll skip Bear Creek versus Peru, but basically the upshot of that example is Peru said, okay, Bear Creek lost their concession because the local community raised the fuss and Peru pulled their concession. Liability was found Peru was found responsible for pulling the concession. Its defense, one of its defenses was, well, you guys caused it because you didn't even talk to the local community. And the tribunal found that that was not sufficient, but you can start to see how causation itself could be not only a sword, but a shield. Like, actually, you caused it, claimant, because you didn't do the things you said you would do environmentally to protect the space, right? So interesting issues there. And let me get Bill Kahn, and then I'll stop quickly. I have no idea what the time is. All right, Bill Kahn. I think this is interesting because this is SIMA, right? This is SIMA as president. Bill Kahn v. Canada. The tribunal took a pretty restrictive approach, but it was one that really turned, in my view, on the causation inquiry. So the tribunal concluded that Canada had denied a claimant a lawful environmental review, right, in regard to a proposed quarry and marine terminal. Basically, claimant wanted to build a quarry and a marine terminal. Canada said, you know what, we're not even going to let you we're not going to let you do this environmental review. We're just not going to, like, the people don't want it. We're not going to do a study. Now, they brought a claim. And the claim was, you should have let us do that study, right? And the tribunal found that claimant was not entitled to full damages because it failed to prove, claimant failed to prove that the flaws in the review process, but for the flaws in the review process, it would have obtained the requisite permission, right? So they said basically, fine, Canada should have offered you this process. That was a FET violation. But because it was arbitrary and it was not, legitimate expectations, very expansive reading of legitimate expectations in Bill Kahn. But we don't know what the outcome of that process would have been. So you haven't proven causation. And then they reduced damages by a significant amount. So there again, causation, at few litigators, causation can be a very powerful tool. In part, its power comes from its flexibility. It comes from its vagueness. It comes from its kind of ephemera, right? It's almost kind of philosophical. That's its power as a litigator, but it is a very powerful tool in apportioning responsibility as a legal matter. So let me conclude with just the future, the next 20 years, and why I think causation is worthy of your time as young practitioners. What does it mean to have a state responsible for causing harm in the sanctions context? Think about the invasion in Ukraine. Obviously, Russia caused harm in Ukraine, upwards of $1 trillion in horrific violence, harm, etc. Russia caused that harm. But what about all the other claims that are going to be brought in that space? Who caused what? How? Who's responsible? These are This is a singular moment, a very horrific moment that will probably define many of our careers for the remainder of their careers, if you're not too young on the Young ICSID side. But causation in that space is just starting to be unwound. Second, climate change. Think about climate change. Who caused climate change? States are taking measures that sometimes may run afoul of existing bilateral investment treaty obligations, right? Obligations that were drafted in the 90s that don't necessarily accord space for environmental indirect ex pro and things like that. Who knows how that's going to shake out? There's only so many times you can write for greater certainty in a supervening treaty. So I don't know what causation in that instance means. The pandemic, any number of ways to look at that. Geopolitical events, and then the one that I'm really, so geopolitical events, there are some war clauses, there's central security, things like that, but there are other ways to think about geopolitical events that might domino into an effect that binds a state's hands, and then which state actually caused that harm to the investor and whether it's compensable or not. And maybe ISDS doesn't answer these questions, and that's okay too, right? Our field doesn't need to answer everything. But the last kind of point on this, which I think is really, in my view, the most interesting, is multilateral action. So you've now seen over the last year almost G7 coordinated action against one state and one jurisdiction. You've seen multilateral action in climate change in Paris. You've seen various groups of multilateral state actors that have impacted the global economy and, by definition, investment, right? If a multilateral group acts in contravention of international law and harms your investment, who bears responsibility? Now, some will say there's joint and several liability and the state should bear full responsibility if that state has signed up to a treaty in a bilateral basis. Others say that that's too broad a scope. So, and that, for me, that all comes down to causation. So I'll stop there.
All this vocabulary reminds you of torts and negligence law. I mean, it's very interesting. I don't know to what extent international tribunals have actually gone back to that thinking. There's been a lot of thought on that. I don't know if you found that when you were looking at the
Yeah,
cases.
no, they don't go to it the way that law students in the United States would go to it. It's not Paul's graph. It's not the clock falling on your head, right? But it is about probability. It's about certainty. It's about proximate cause, right? I mean, it all sounds in that language. But of course, one thing that we're taught as international lawyers is don't apply a torts framework to a state because states are different, right? So there's a tension there.
Interesting. David, I'm going to turn to you. We know that most of the cases result in damages, and certainly the ARSIWA has a lot of good provisions that help you and have been invoked in that sense. But increasingly, we're starting to hear conversation about non-monetary remedies. And we haven't seen a lot of cases applying that analysis, but the ARSIWA at least seems to give you an avenue into non-monetary remedies. And that was what you looked at in your contribution. So we wanted to hear your thought about, does it give you a basis for non-monetary remedies, and are we going to start seeing more of that in investor state cases?
Well, thank you very much. It's a privilege to be part of this panel, and it was also really an honor to be able to contribute to this fantastic volume that we're here to celebrate. So let me start my thoughts from a non-ISDS perspective. Before I went into arbitration, I spent several years doing human rights research. I actually wrote an article on non-monetary remedies in the Inter-American human rights system. I was always impressed by the nuanced way in which the Inter-American Court of Human Rights attended to multiple dimensions of injury which arose from a breach of international law, and especially how it made it possible for a victim of a human rights violation to live in his or her society, to rejoin that society and be a full member of it, or at least they tried to. That was the goal. This system makes ample use of cessation, restitution, guarantees of non-repetition, and measures of satisfaction to craft comprehensive remedies that attempt to stabilize the relationship between the victim and the state and society, as well as to undo, which is sort of the more typical objective we see in an investor state, but to undo to the maximum extent feasible the injury that's been suffered. So obviously, ISDS is not human rights. It necessarily involves a foreign investor. They're usually, or almost always, economic in nature, the disputes that we see. And when a dispute gets to the point that the arbitration ensues, the foreign investor is often ready to call it a day, pack their bags, and go home. Really, the only question at that point for many investors is how much money they can get paid to cover their economic loss that was caused by the state. But while that's a common scenario in investor-state arbitration, it's not always the case. So two scenarios come to mind here for me. First, there's always the possibility the investor actually intends to remain or wants to remain. Maybe it can't leave. For example, if your investment suffered an FET breach as opposed to an outright expropriation, you may well still have an investment in that country. And if that FET breach arose from sort of antagonistic actions by the state, you may really have a problem there that goes beyond just the pure economic loss, but another aspect of a problem that you might want to solve through the international investor-state arbitration mechanism. The other scenario we have is that maybe an investor, in some cases, is injured in ways that go beyond a mere economic loss. Now, of course, that's the most common scenario where the state's grabbed or is accused of seizing a factory or whatever. But sometimes the allegations go beyond that to a pattern of harassment, sometimes even physical assault or false imprisonment of various sorts. And in that sort of scenario, you might think that a purely economic remedy doesn't really capture everything that's gone wrong in the relationship between the state and the foreign investor. So the ILC articles and their commentary notably says that the remedial principles apply only to state-to-state disputes. But of course, this hasn't stopped tribunals from citing them, as Patrick mentioned, at least citing the principle of full reparation and more generally the principles on monetary compensation. These are cited in many, many cases. Yet we find that tribunals are much more reluctant to invoke the Articles on State Responsibility when it comes to non-monetary remedies. And surprisingly, in many of these cases, they don't even actually cite concerns of enforceability. They just don't really want to get into concerns of non-monetary remedies that go beyond sort of the pure economic injury. So this is really a deviation from that general pattern where tribunals grab the articles as sort of that board in the at sea to keep them afloat. Here they don't really want to don't frequently grab onto these particular planks that the ILC articles provide. And this may actually be most striking in the case of restitution. And why? Well, the ILC articles suggest that restitution is actually the preferred remedy, and that the other remedies are available only insofar as restitution does not make good the damage suffered. That's in the ILC articles, but it's not really typical in investor-state practice. So perhaps in part for that reason, because restitution is, at least in some sense, a theoretically preferred remedy, it also tends to be the most common non-pecuniary remedy or non-monetary remedy that we actually see in investor-state disputes. So several tribunals have addressed restitution. They've given the state the option of either providing restitution or compensation at its election. Perhaps this might be out of some sort of implied concern for state sovereignty. Some tribunals make that explicit, but a number of tribunals that have ordered these sort of alternative remedies have not. But sovereignty actually is not a factor that the ILC articles focus on either in their official text or in their commentary. Other tribunals, and for example, just the Von Pezzel Tribunal, I think, is probably the poster child for this particular approach. They've made it clear that the state has the obligation to pay restitution, but that if it doesn't comply with that obligation, then it must pay compensation. It's a little different. That tribunal is not saying that the state really is supposed to have a choice. It's backstopping its restitution remedy with a compensation, and this allows it to circumvent any sort of concerns about enforceability. If you're afraid that the state may not comply with the restitution order, then you better give the investor some sort of alternative so that they have something to get when if the state does not comply. Now, sometimes restitution actually shades into cessation, and this can occur especially when we're considering the reversal of legal acts, change of a law, adverse court judgment, something like that. So in many cases, these could be viewed either as the remedy that tells the state to undo this act could either be viewed as trying to restore the situation prior to the unlawful act, or in some situations, making the attempt to order the state to cease an ongoing unlawful act. But regardless of how we categorize this, at least here we've seen one or two tribunals that have made sort of unqualified orders of either restitution or cessation. They don't always distinguish between these categories. So for example, the ATA versus Jordan Tribunal ordered that the claimant's right to arbitrate a dispute should be reinstated. This was following the Jordanian court's extinguishment of that particular right. So we see these sort of these either restitution or quasi-restitution remedies from time to time in the case law. But what we don't really see very much of at all are orders of measures of satisfaction or guarantees of non-repetition. Remedies that might be aimed at addressing kind of more dignitary aspects of the wrong, or trying to really actively restore an ongoing, good working relationship between the state and the foreign investor. Now, probably one reason we don't see these very often is they're not actually sought very often. But at least one tribunal has addressed measures of satisfaction directly. This is the Kiberax versus Bolivia Tribunal. And that tribunal rejected them on the grounds that satisfaction is a measure reserved for states, and that human rights practice suggests that monetary remedies suffice. So you can see some hesitance on these part of these tribunals to go in that direction, even though actually in human rights practice you will occasionally see, or you'll see actually fairly extensive use of these remedies to try to address the entirety of the situation, restore that relationship, address kind of non-monetary aspects of the injury or non-economic aspects of the injury. So what can we learn from human rights practice that may be relevant to investor-state dispute settlement? So first, I think we can learn from human rights practice that concepts on non-pecuniary remedies may be transferred from the Articles and State Responsibility, even if we have to make some modifications for the context. Even in the human rights field, when they apply concepts like measures of satisfaction, guarantees of non-repetition, restitution, and so on and so forth, they've evolved. They're not the same. They're not exactly the same as you see in the ILC Articles, which really had more of a focus, or perhaps had a bit more of a focus on the state-to-state context, or at least so they say. So second thing we can take away, the types of remedies for private parties are not necessarily more restrictive than those for states, and indeed, they may be more expansive. Human rights adjudicators have awarded measures of rehabilitation, for example, to individuals. That's not something that appears in the ILC Articles, but it is something that's kind of sensible, especially if you have somebody, a victim of a human rights abuse that has suffered physical or mental harm. Now, of course, this doesn't translate to the business context that we see in investor-state dispute settlement, but it does raise the question of, well, are there similar sorts of harms that might require appropriate responses in the investor-state dispute settlement context? I think this is a question that that the human rights practice raises. Third, I think we also can see that the types of injuries that private parties may suffer are not purely economic, although they can be, and in many of our cases they are economic. It may be symbolic or dignitary. It may involve pain and suffering. Loss of reputation can be one that we might very commonly see in this context. Sometimes you also see, in the human rights context, at least harm to collectivities, but maybe that's actually also transferable context. A lot of times we're dealing with corporations. It's possible that something the state has done could, in some way, damage the corporation beyond just its economic loss. And even then, we have the relationship of the investor to the state and the stability, or at least dependability of that state, of that relationship, that the state's not going to take unwarranted adverse actions against a foreign investor. Then finally, I think the fourth lesson that we can take from human rights practice is that monetary compensation is not always sufficient to fully address many types of injury. Reputation, for example, is not purely monetary in nature. It does have a monetary effect, especially for a business, but it's not solely monetary, and it may be more appropriate, or at least also appropriate, for a state to make efforts to cleanse the reputation of the foreign investor if it has, for example, engaged in some sort of pattern of harassment in the public media or something to that effect. And one way the state could go about this is making certain public announcements that would address or sort of take back what it had previously said. So the point I want to make is not that ISDS should necessarily adopt all elements of human rights practice or provide non-monetary remedies in all or most cases. Probably shouldn't. The cases often are more economic in nature, by and large. But instead, the point is that the ISDS system, while has not really embraced the full range of tools that may be appropriate in achieving full reparation for injury. And by failing to embrace this full set of tools, it hasn't really fully addressed or fully realized its capacity to actually try to restore the kind of working relationship between a foreign investor and the state. Thank you.
Yeah, I mean, it may be that council should actually be thinking about non-monetary and monetary. I think most of the time when we go to a case, we go straight from liability to and how much the damage is. It may be that that's also a part of lawyering that we could take on.
Yeah, I do think that one of the major causes is that these sorts of remedies are not sought in many cases. I mean, you do have to have a particular type of case where they would be appropriate.
Exactly.
And maybe also there are some concerns about enforceability, but I do think the von Pezzold approach actually can solve that enforceability problem across sort of the range of non-monetary remedies. Just backstop it with compensation.
Exactly. Good. Thank you, David. Christina, we're going to go back to our happy spot, which is compensation, monetary awards, and in particular, you looked at damages and interest, awards of interest, and the accumulation of interest. And we know that this can be huge, that we often don't think about it, but an award of interest, and especially if that award is not satisfied quickly, the accumulation of interest over time can become a major amount of money. And so knowing what the law is on this is really significant. And of course, the ARSIWA has a number of provisions that address this, and you looked into those. So what was your conclusion about what we ought to know and the intricacies around that?
Thanks, Meg. Good evening, everyone. It's a pleasure to be here, and I just wanted to start off by thanking the organizers for inviting me to participate on this really eminent panel. And I'm also appreciative to ICSID for asking me and my co-author, Juan Pablo Villegas, to contribute to the special issue and on this particular topic of interest. I think many of us refer to the articles in our pleadings and our academic work, as well as commentary, but this was really a unique opportunity to dive more into the Travo, which I hadn't done prior to this. So that's where I propose to spend some time, is sharing our findings on the evolution of interest at the ILC. So in this short talk, I propose to cover three main points. The first is to take you through the ILC discussion on interest. And then next, I will give a brief overview on arbitral practice on interest, and finally conclude with some reflections on this practice and whether it's consistent with the ILC articles and the commentary itself. So before I get into the ILC's work, I wanted to first situate the Article 38 within the Articles on State Responsibility. It's found in Part 2 concerning the content of international responsibility of the state. It's one of 6 articles in Chapter 2 on reparation for injury. The other articles concern form of reparation, restitution, compensation, satisfaction, and finally contribution to the injury. Article 38 itself comprises of 2 subprovisions. The first part provides that interest on any principal sum due under this chapter shall be payable when necessary in order to ensure full reparation. The interest rate and mode of calculation shall be set so as to achieve that result. And then second, interest runs from the date when the principal sum should have been paid until the date the obligation to pay is fulfilled. And this is in turn followed by 12 paragraphs of commentary. So how did we get there? Permit me to take you back in time. We can trace the ILC discussion on interest back to 1961. The story here is short. At the time, the special rapporteur, Garcia Amador, had concluded that interest was not a generally accepted rule in the writing of authors or in practice. But fast forward almost 30 years later to 1989, the 4th special rapporteur, Professor Arangio Ruiz, put interest back on the table. And he proposed a draft article that linked interest to lost profits, that established the period of interest as running from the date of the breach until the date of payment, and permitted, surprisingly, compounding whenever necessary in order to ensure full compensation. The proposal was eventually rejected for linking lost profits to interest and allowing for compounding. But what I think is really striking here is the complete reversal of the ILC's position on interest at that point. We posit that this might be due in part to the creation of the Iran U.S. Claims Tribunal, which had been grappling with issues of interest at that time. So after that, another proposal on interest emerged in 1993, but it was really not until Judge Crawford took the helm of the ILC that the present formulation really took shape. And in this current form, Article 38, in our view, seeks to achieve a balance between providing some guidance on interest while preserving the discretion of the international adjudicator. How does it do this? Well, Article 38 does not specify in what circumstances interest would be necessary to ensure full reparation, nor does it specifically state when the period of interest should start. And importantly, it does not provide any guidance on what rate or mode of calculation would achieve that result. So what we're left with is tribunals making their own determinations on these issues. And that brings me to my next point on arbitral practice. So we looked at investment case law, which is very rich on this topic of interest, since the principal remedy sought is compensation. And what we observed really is that there was no true uniform approach on these main elements, which are the time period, the rate, and the mode. Although, with respect to the time period, most tribunals appear to adopt the date of the breach. This can be a complicated exercise when we're dealing with multiple breaches over a long period of time, and there have been different approaches on that issue. In terms of the rate, parties often differ on whether to use risk-free rates such as T-bills or certificates of deposit, or some higher rate like an interbank rate plus a premium, the claimant's cost of capital, or the sovereign's borrowing rate. And as a result, rates are really all over the map in the case law. Ultimately, I think the rate that is used depends on the arbitrator's view on the role served by interest. That is, whether interest is simply to compensate for the time value of money, or for the loss of a particular use of that money. And as for the mode of calculations, arbitral tribunals are showing a greater willingness to order compound interest. And, this contrasts with the approach taken in interstate disputes, and even in international commercial arbitration cases. And we can return to that if there's time in the Q&A, but I think that's a pretty interesting observation based on some surveys that have been taken. But in the interest of time, I'll move to my final point and conclude with two observations on the conformity of international arbitration practice with the ILC Articles. First, interest, as we've seen, is routinely ordered in investment arbitration, which may, be appropriate in the majority of cases, but I think it's still incumbent upon tribunals to take that preliminary analytical step to determine if interest is indeed appropriate in a given case, rather than simply assuming an automatic entitlement to it. For example, interest may be deemed inappropriate when the loss relates to a non-economic damage like pain and suffering, for example, or if the claimant has delayed in bringing the claim due to no fault caused by the state. The second issue is with respect to compounding. I think it's really surprising that on this one issue where the ILC seemingly took a firm position, the case law has moved in the opposite direction. And the commentary shows that the ILC was very much aware of this gradual move away from simple interest, but still barred compounding absent special circumstances which justified its application. And because of this, we called for a renewed examination into whether the practice of investment tribunals on compounding still reflect the ILC Articles. And if not, how should we understand this departure or this shift? Is it lex specialis, jurisprudence constant, which many arbitral tribunals refer to? Or is it perhaps reflective of a new customary international law? I mean, I know these are big questions to leave you with, but the main takeaway is that the decisions of investment tribunals have largely been consistent with the ILC Articles, and I think that's largely because there was a lot of room carved out for arbitrator discretion. But I do think there is still need in some respects for more well-reasoned and justified decisions on issues like entitlement to interest and compounding. So I will end my remarks here, and I thank everyone for their attention.
Thank you all for going through what you focused on in this review. We wanted to move quickly to 3 examples of how the state responsibility articles apply to some of the things we're reading about now. And the first one that I wanted to raise was the whole question of sunset clauses. We've seen a lot of media discussion recently in the context of the Energy Charter Treaty and debate about modernization and debate indeed about whether states will continue to be governed by the Energy Charter Treaty. And the question comes up about denouncing the obligations and what kind of guidance the state responsibility articles might provide. And Freya, I know you had some thoughts on this, and Patrick, and why don't we open the floor now?
Yes, thank you very much. I'd be happy to. So sunset clauses are addressed by a really interesting article by Professor Reinisch and Ms. Spala in the ICSID review. I would very much recommend you to read it. As to my thoughts, well, first of all, just to see that, to make sure we're the same, we're talking about the same thing. So I'm talking about these clauses which say that even if a treaty is terminated, with respect to investments that were made or acquired prior to the date of termination and to which this treaty otherwise applies, the provisions of the treaty remain effective for a further period, which can be 10 years, 15 years, 20 years from the date of termination. And the discussion then is whether that means that current proceedings that are being litigated can continue. I think most people would say yes. But then whether, to what extent an investor who fulfills the criteria can initiate new proceedings and enjoy substantive rights, of course, that's more a matter of discussion. If we look at that from the lens of the ARSIWA, I would say sunset clauses would allow for the principle of intertemporal law in Article 13 of ARSIWA to be applied, which states that an act of a state does not constitute a breach unless that state is bound by the obligation in question at the time the act occurs. And then the question is, of course, if the act occurs after the treaty has been terminated, is the state still bound? For sure, if no sunset clause is there, it would be much more difficult to argue that there is such an international obligation still in place. But even if the sunset clause is there, one question that could be raised is, in light of Article 33, saying that we have to be talking about a right that accrues directly to any person or any entity. Are the substantive rights under the BIT actually rights that are owed directly to the investor? Another question is, can the investor continue to accept the offer to arbitrate, or is that something that should have happened before the treaty is terminated? There, in the case law, what you see is there's a bit of a discrepancy here between tribunals that have said that it doesn't matter, sunset clause applies whether there's a unilateral termination or a mutual agreement between the parties to terminate treaties, on the one hand, and on the other hand, there have been a number of tribunals that said no, this only applies, sunset clauses only apply in cases of unilateral termination. As soon as there is an agreement between the parties can, when they terminate a treaty, implicitly this would imply that the sunset clause is not applicable. Another question here, I think that has already given rise to some discussion, might give rise to some cases in the future, is what if there are newly negotiated treaties? So, for example, Colombia and Peru had a BAT that had a sunset clause that said that for 10 years such cases could be brought. That BAT was replaced in 2010 by a new BIT, and both states agreed that a new BIT would completely replace the old BIT, and claims could only be brought under the old BIT, under acts that happened under the old BIT for a 3-year period. So this 3-year statute of limitations was agreed upon by the parties, which was not, of course, not an implicit termination of the sunset clause. It was actually rather explicit, but unfortunately, well, not unfortunately, as an academic I would say unfortunately no cases have been brought. The parties in question might actually be quite happy that no cases have been brought, because the question is, if you don't say this sunset clause no longer applies, if there's no such explicit statement, could such a 3-year statute of limitations be seen as a violation of the sunset clause? Maybe one final point, on being mindful of the time, is that if we look at Article 54B of the DCLT, the question is also what should happen with sunset clause if there is an agreed termination. So at any time, termination can happen at any time by consent of all the parties. Does that then override an agreed provision such as a sunset clause? I think some states have clearly taken, tried to opt for the certain way. They have first amended their BIT in the sense that they abolished or modified the sunset clause, and only then did they terminate it. And it's interesting in that regard to look at the state practice of the Czech Republic, of Australia and Indonesia. But I'd like to stop here in order to give my colleagues a chance to say something. Thank you.
Well, once again, I have to follow Freya, which is not a good situation for me personally. And in the interest of time, let me just do two things. Perhaps outside the scope of the mandate, which is connecting it to ARSIWA, because I don't think there's anything left to be said after what Freya said. But I do think that it's interesting to me that, and I won't go into too much substance here, but it's interesting to me that the states that are looking to terminate the ECT are doing so with full knowledge that the sunset clause is 20 years. Because if you were to modernize the ECT and do what the Commission wants, you would remove, theoretically, a lot of the quote-unquote problematic cases in the fossil fuel industry, et cetera, that is causing concern in Europe. And instead, they've gambled, perhaps, on withdrawal, unilateral termination, and then hopeful non-applicability of a 20-year sunset clause. And of course, that's interesting. And there are all sorts of VCLT analysis that will happen. But the point that I'd want to make, which might send a chill up Meg's spine, who knows, is I do think that a lot of this is going to be determined by non-state actors who need to register or think about these claims, right? Because you can imagine a situation, and the ECT Secretariat itself has said that this is impermissible and that it requires changed circumstances, which is VCLT 62, and that's not applicable here. But you could imagine a question will arise prima facie at registration. Right? Now, there are termination examples that have come before ICSID in the past, but it's an interesting question, and certainly this might be subject to the expedited manifest incapable of being whatever the new 41.5 is. What is it?
Manifest lack of legal merit.
No, I know the standard, but 41.5 has now become...
Oh, it's still 41. We managed to do that.
41.7 now, I think it is.
Yeah.
Okay, so, I mean, but that also has a different procedure. So a lot of these very heady questions will be resolved in a very kind of rapid way, and non-state actors might be kind of at the forefront of it. So that's an interesting aspect of this.
And you can see a lot of them coming up at the same time.
Yep.
It would be nice to deal with them all at once, in a way.
Send some guidance out.
Let's move to state succession, which is another area. This is a number of cases we've seen where a new state or the government of recently claimed territory is alleged to be responsible for consequences of internationally wrongful acts committed before that succession. And the question is, can the state responsibility articles help us out in that circumstance? And we've seen a few cases. David, what do you think?
So let me just start by commending Conan Dunbury's excellent article in the special issue on this particular topic of state succession. I note, though, that one of their conclusions is that actually the ILC articles don't have that much to say about state succession. And this does seem to be true as a matter of the bulk of decided cases, which typically focus on succession in respective treaties. That's addressed by the 1978 Vienna Convention. But as these authors note, as of present at least, the IDI resolution on the succession of states in respect of state responsibility is perhaps the most comprehensive statement we have on succession of state responsibility for conduct of predecessor states. I say we presently have, because the ILC is hard at work on this topic and there are actively new reports being issued. But I think there are some interesting issues here where the ILC articles can contribute. It seems that a key emerging principle, or at least in the IDI resolution, is that the succession of states should not simply erase state responsibility. Somebody should be responsible, even if there's a change in what states exist. So the challenge instead is to determine where state responsibility should fall. And I'm just going to address just a few scenarios, and specifically ones in which I think the ILC articles may have some relevance. So first, suppose an insurrectionary movement succeeds in establishing a successor state, a new state, on part or all of the territory of a predecessor state. Well, here Article 10 of the ILC articles is directly relevant. It tells us that the insurrectionary movement's conduct prior to becoming the state is attributable to the new state. So there's something about what happens here, or at least the relationship between the movement, the non-state movement, and its new form as a state. So the underlying principle here, though, I think is interesting. It seems to be that certain aspects of attribution principles can apply even to certain sub-state or non-state entities. Another scenario. Suppose part of a predecessor state succeeds in breaking off and forms a successor state. It may generally not be responsible for the actions of the predecessor state. However, it may be responsible if the action at issue, the wrongful action at issue, was committed by one of its organs. So the scenario we're imagining here is where the new state, maybe it's a local provincial government, splits off, and prior to splitting off, one of its organs committed some sort of wrongful act against a foreign investor. Well, it may well be that it inherits a responsibility because it's got the continuity of sort of its subcomponents. So, for example, if a governor of a province unlawfully expropriates an investment and the province becomes a state, it may not be able to escape international responsibility. But what if a state-owned enterprise, for example, commits the action? Well, here we could easily see that the issue of succession dragging in Articles 4 or maybe 5 on attribution of acts by state organs and entities exercising governmental authority. I mean, these could be relevant to assessing that particular scenario of state succession. Finally, and just the last example, suppose a successor state maintains a supposedly continuing act or a series of acts from before it's separated or became a new state and afterwards. It may be the case that the entire series of actions or the continuing action is attributable to the new state. So, I mean, creeping expropriation or some sort of FET breach that kind of extends in time from before the creation of the new state. Well, the IDI resolution here suggests that the new state may be responsible for the entirety of the continuing act of the series. But to determine whether we're actually faced with such a situation with a continuing act or a series of acts that are collectively wrongful, we may want to turn to Articles 14 and 15 of the ILC articles, which address exactly the nature of continuing acts or acts that in a series violate international law, and they may be relevant to addressing this scenario as well. So maybe, I think it's taking a step back. I think it's hardly surprising that the law of state succession and that of attribution could intersect. Both of these areas of law have to address the challenging question of what is a state? What are its parts? And the circumstance of state succession in particular raises these questions in their most stark form. When part of a state is broken off, or when the state is completely dissolved into whatever constituent parts it may have, which of those parts drag their responsibility along to the new state?
Thank you. Freya, do you have any thoughts on that?
I had lots of thoughts, but in light of the time, I was just thinking of sharing one.
Good.
I think David did a terrific job of already discussing the link with the ILC of this state succession and how insofar the ILC can help. I thought it's interesting to look at practice, and then of course practice is not uniform in this respect. And one set of cases that I followed and that I've been working on a bit myself is the cases to what extent the Chinese territories that have been incorporated in China, and I'm thinking of Hong Kong and Macau, how they have resulted in a limited number of cases. And why is it interesting? Well, because there appear to be domestic regulations concerning how Chinese treaties are applied to these territories. Although you could, of course, question to what extent domestic regulations are opposable in treaty law. But what is really interesting is that some tribunals have really just not accepted what the internal regulations said. So to briefly sketch the problem, most Chinese BIT do not stipulate whether they apply to what are called the China Special Administrative Regions. The only exception there is the BIT with Russia, actually, which says that it doesn't apply. But what we do have is in 1984, we had the Sino-British Joint Declaration on Hong Kong, and followed by the 1987 Sino-Portuguese Joint Declaration on Macau. And then what happened was that China, as it took over these territories, notified the UN Secretary General of a list of treaties that would apply to these territories, and none of these, in neither list contained any BITs. So the assumption was that these BITs would simply not apply, and everybody bumbled along quite happily for a number of years. And then a number of cases were brought under the China Peru BIT and the China Laos BIT. And in these cases, investment tribunals said, yes, there is no reason to assume that these treaties do not apply. Now, that was criticized also by Chinese scholars that said, well, we have this one country, two systems, or one country, three systems. And even also the other parties, Laos, for example, protested. China protested, said we never intended these treaties to apply. And this was then fought out in domestic courts, in Singapore more precisely. And then funnily enough, in Singapore, the Court of Appeal agreed with the claimants. So in spite of letters from both treaty parties that treaties did not apply, that there was no, well, not really succession, but no sort of no, well, in a way it is, application to these territories, both the investment states tribunals and the the Court of Appeal of Singapore decided that they were going to apply these BITs. Now, China, I can explain at length why they did so. It was more a temporal question, because these letters of the countries had been published after the dispute had already been decided by the investment state tribunals. But to this day, China, for example, denies that these awards, were correct, and keeps saying that there is no succession in this regard, no application of its treaties to territories that are, for all other sense and purposes, very much firmly part of China. And I just happen to think that's an interesting modern application of succession of treaties. Thank you.
Good, thanks. And does anyone in the audience have questions or thoughts to add? Or would you prefer to do that over drinks? All right. With that, then, why don't we bring this to a close? I want to thank you very, very much for your attention, and invite you into the hall, and thank you very much to Allen Overy for hosting us tonight. And we hope that you will take a look at this volume. I think you'll find it's really useful. So thank you, and thank you to our speakers.